We are reconvening this remote hearing of the Judiciary, Finance, and Civil Law Committee. It is still March 15th, 2022. We still have the quorum from earlier, so we will get right to it. We've got a lot of bills on the agenda this evening. First, we'll start with Representative Koegel. I will move House File 3768 be referred to the Commerce Committee. Representative Koegel, please tell us about your bill.
Thank you, Madam Chair. Members, good evening. Sorry, I'm still struggling with daylight savings time. I think I'm going to be a co-author to Representative Freiberg's bill here. But I wanted to talk to you today. House File 3768 is a structured settlement bill. And I think over the summer, we all saw the expose in the Star Tribune about this practice. And so I'm kind of going to draw a little bit of a picture for you about how this has been working. So let's say you're in a horrific accident. It's not your fault. It leaves you seriously and permanently injured and perhaps cognitively impaired. And you win a settlement for $2 million. Rather than taking that lump sum award, your attorney advises you to have the insurance company paying out the claim to work with an annuity company to set up what is called a structured settlement, which consists of installment payments over perhaps the rest of your life. This way, you're assured that the necessity of life and future medical needs will be taken care of, not only for you, but also for your children. In the 1990s, an industry emerged whose goal it was to induce you to part with the money you will receive over your life for a single payment now, typically in a much lower amount than it's worth in present day dollars. These companies are called settlement purchasing or factoring companies. And you may have seen these advertisements. I don't know if anybody's homesick watching Price is Right. You get the J.G. Wentworth, it's my money, I want it now. I'm sure we could all sing those jingles together. And so those are the companies that we're talking about. By the late 1990s, the aggressive and often abusive tactics of this industry led the passage in all 50 states, including Minnesota, of the Structured Settlement Protection Act. This act was intended to protect these vulnerable, often extremely unsophisticated, and often cognitively impaired potential sellers from being bamboozled or taken advantage of. The law established an unprecedented court of approval process for these deals. So in few, if any areas, it is necessary to have a court approve a marketplace transaction between a buyer and seller. And that one was set up here. It tells you everything you need to know about the dangers inherent to selling these in these situations. So in October of 2021, we all saw the Star Tribune publish a shocking investigative series about the predatory practices of many of the biggest players in the structured settlement purchasing industry. And I draw your attention to your packets with some excerpts from the series that are provided. The revelation from this series are appalling, and let me just go over a few of the problems that it revealed. First, sellers are often they often get a small percentage of the present value of their settlement. The series reported that on average, sellers only received 40% of future payments in cash. One Lino Lakes resident whose skull was partially crushed when a 12,000-pound concrete sewer culvert rolled over left him without most of his teeth, blind in one eye, and his face permanently scarred. He never finished high school. He was induced to sell his settlement, and he will not receive another check until he's almost 80 years old. Altogether, he sold $1.5 million in payments to one of the biggest purchasing companies for $226,000. That's about 25% of what the payments were actually worth. Second, many of these victimized sellers are kids who are turning 18 and received their settlement because of injuries sustained by minors, and now are being bombarded with calls and texts offering quick cash. And I don't know how many of you as college students saw credit cards and were like, ooh, free money. But that's kind of what I'm sure a lot of these 18-year-olds are thinking too. And third, the series revealed how existing law, including new disclosure requirements passed in 2014, are having little impact. Judges, one of whom you'll hear from next, indicate that the current law is vague and with no standards for formulas, guide to the process. They're crying out for this for the legislature to provide clear guidance and tools to enable them to determine whether the terms of these deals are fair and reasonable, and whether the overall transaction is in fact in the best interest of the seller. And so another judge, now retired, told the Star Tribune there is no ready way for judges in Minnesota to obtain assistance in these cases because it's not built into our law. I have no doubt that these judges would welcome the assistance of an independent fact finder who reports to the judge. There's, a series, the series identified aggressive marketing campaigns, and also they were getting 10 to 15 calls per day from a company. And so what House File 3768 provides desperately needed reform to the 1999 law to address these unconscionable situations. It does not outlaw the purchase of structured settlements. And so with that, I'd like to turn it over to my testifiers. I think they can better express the need for this. Thank you.
All right. Thank you, Representative Koegel. And I do know that a lot of folks worked many hours in working to put this bill together. So appreciate all the efforts in trying to find a workable solution.
Madam Chair, I'd like to dub this bill as the I just cut my fingers off, please give me lots of work to do bill. So this is the one that kept me busy during a time where I was feeling kind of sorry for myself. So
well, it's a big one. So good work. First on the list, I have Judge Arlene Perkio. Please introduce yourself for the record and go ahead with your testimony.
Thank you, Madam Chair. My name is Arlene Perkio. I am a judge in the 1st Judicial District, chambered in Dakota County. I've been on the bench for 11 years. As a part of the regular special term assignment, these cases have been in front of me on and off throughout those 11 years. And they've always been somewhat bothersome. As I reviewed the proposed bill, what struck me was the changes that were made as far as the individuals giving advice to the people that were looking to actually get some of this money. And that has been something that I always ask, well, who advised you? How'd you get that name? And it's usually a list of names that's provided by the actual company that's setting the whole thing up. And but they're independent, they're on their own, but it just doesn't feel right. There's one particular case that I remember where a woman was so strung out in the courtroom. She was coming down off of meth or heroin. She just was barely coherent. And I didn't think she was competent to proceed. And I said so. I mean, that's what happens, right? If you're inebriated in the courtroom, you're not competent to proceed. And the attorney that was representing the business said, well, the attorney who was representing her thought she was competent and advised her that she should take this. Like, just totally missing the idea that here at this critical moment, when the testimony under oath was needed, that she wasn't getting it. And it was also a situation where what she needed it for were bills. It seemed very unclear, very abstract, and I didn't think she fully understood. I denied that one and then blocked it to myself. So if it was repetitioned, it would come back to me and I would remember the history of what happened with it. It's those kinds of cases. I just can't stress enough. I have never felt good about any of these. I see people who, for the most part, are in financially desperate situations and do not fully understand what they are doing and how much money they are actually losing. Thank you.
All right, thank you for your testimony. We'll just note for all of our testifiers today, we have a lot of bills and a lot of people signed up to testify, so we are going to limit testimony to 2 minutes for everyone. You did a great job, Judge Perkio, but for the rest of the testifiers this evening. Eric Vaughn is next on the list. Please introduce yourself for the record and then go ahead with your testimony.
Madam Chair, thank you very much. My name is Eric Vaughn. I'm the Executive Director of the National Structured Settlements Trade Association. We're the organization that puts together, builds the structured settlements for seriously injured people all across the country. We have a very unique membership, and I know everyone says that about their own association, but ours is quite unique. It's an industry association. We represent all the major life insurance companies, property and casualty companies, and structured settlement consultants who work with both the plaintiff and the defense side directly with injured parties. Our members, and I want to stress this, work directly with the injured party and their counsel. And the reason that's important is because they get to know the person, his or her family, the medical issues, the security needs, the health requirements, because they're putting together a long-term lifetime plan to help address those medical, health, living, life concerns for the annuitant, the payee, and his or her family. They can spend months, sometimes, Madam Chair, years building a structured settlement. So it takes a great deal of time, energy, and effort and commitment on the part of our industry association, especially our life company partners. I can't stress their leadership and commitment enough. But a structured settlement was established by Congress about 36, 37 years ago as an act of Congress, putting out very specific and precise tax rules that provide the compensation claim can be made to a claimant tax-free. Congress did that in the knowledge that the claimant and his family would never have to come back on public assistance. They would always have the benefits of their structured settlement to take care of their health care, medical care, living expenses. For 25 years, our association has worked with states all across the country. While one of the very first states to pass an SSPA was Minnesota back in 1999, just 8 months ago, the 50th state, New Hampshire, passed their SSPA. We're committed to making certain that these rules work. We're committed to it for a lot of reasons, but there are 3 very specific items I want to mention in Representative Koegel's bill, because our industry enthusiastically supports this legislation. The best interest language, I think, is excellent, Representative Koegel. You did a fantastic job. You've already mentioned the appointment of an evaluator. We strongly encourage that maintain part of this bill. And the discount rate issue is critically important. I had about 8 minutes worth of testimony, Madam Chair, so I did try to shrink it, but I'd be more than happy to answer any questions. And I greatly appreciate the opportunity to be with you and your committee as you work on this very important legislation.
Thank you for your testimony. Next on the list, I have Joel Carlson with the Minnesota Association of Justice. Mr. Carlson, please introduce yourself and go ahead with your testimony.
Thank you, Madam Chair and members. My name is Joel Carlson. I own a legal research and government affairs business here in St. Paul, and I'm here on behalf of the Minnesota Association for Justice. And I would like to recognize all the effort of Representative Koegel getting us to this point. I searched my emails today, and our first meeting was October 7th. So we've been at this a long time, and the work product that I think before you was excellent. Our members, as Mr. Fawn indicated, are on the front end of the structured settlements. We represent the injured consumers and their families, and they're intended to provide compensation for them over a periodic time. And we never are on the sales end of these transactions. Our members, if they do get contacted, always advise against it. Because it frustrates the very purpose of what the settlement was set up for in the first place. Mr. Vaughn mentioned the best interest factors or considerations. There's one turn to that I'd like to point the committee to, and that's on page 4 on line 3. We change the law so that it's the judge that makes the decision about what's in the best interest of the payee and their family. Right now, it's the payee that makes that determination to the court, and the courts are very reluctant to overturn that decision for an adult who's before them asking them to sell their assets. That's a really important change And then it's followed by these best interest considerations. What is their income level? Does it knock them off of public assistance if they take these benefits? All of these factors are really important. The second important thing also mentioned is the appointment of an independent evaluator on page 5. We think that's critically important so that the court can get independent advice when they need it. There might be somewhere that's not needed, but many times they would like to get someone independently giving them advice as to whether or not this is good for the consumer. And the third thing that I think is important is on the prohibited practices. All of those are important, but the 7th one on page 8 is the most important to us. It prohibits the sale of a minor's settlement. That was put in place for a reason, to provide for them, possibly for a long period of time. And having your guardian come in and try and sell that from the minor, we think is wrong and should be prohibited. Thank you, Madam Chair. We appreciate you taking the time to hear this bill. And if there are questions, I'll remain on the Zoom. Thank you.
All right, thank you, Mr. Carlson. Next up, I have Craig Ullman. Please introduce yourself for the record and go ahead with your testimony.
Thank you. Madam Chairman and members of the committee, my name is Craig Ullman. I practice law in Washington with the firm of Hogan Lovells. I retired recently as counsel to Mr. Vaughn's organization after 26 years, and I'm now trying to provide pro bono assistance to the proponents of House File 3768. As NSSTA counsel, I drafted the model legislation that was the starting point for all of these 50 state statutes. And I was directly involved in or with enactment or amendment of many of them. In light of the time constraints and to avoid repetition of what has already been very effectively said by the other testifiers, let me just concentrate on a couple of aspects of House File 3768. Point of background, when someone like Judge Perkio is asked to approve a transfer of structured settlement payment rights, it's an odd proceeding because it's not an adversary proceeding. The only parties that are there are the purchaser and the seller, who for good or ill has been persuaded to sell his or her payment rights. So there's no adversary presentation, and that puts judges in an awkward position. And House File 3768 would substantially improve the decision-making capabilities of judges in several ways. First of all, by providing better information or disclosures, which go to the seller as well, but also are available to the court, providing information about any previous transfers, because sadly, when a seller sells payments once, it's likely he or she will sell them again in the future. And most important, the point that's been raised before, is the appointment or the authorization, express authorization for court to appoint an independent evaluator to assess. That relieves the judge of the burden of looking behind the one-sided presentation that is made by the purchaser with the assistance of the seller. Have someone independent look behind that, review the disclosures, and make an objective recommendation to the court about how to proceed. I'm not going to carry on now, but I will be happy to answer questions and happy to be a continuing resource if I can be, because sadly, having been involved with so many of these statutes, I've got a lot of background. Thanks very much.
All right, thank you for your testimony. I always figured Washington attorneys are fancier than us, but you've proved that today. That is the end of my testifier list. I will note that we also have, oh wait, there's one more person. We do have Ron Elwood available for questions if we need him, but then I also have Brian Deere on the list. Mr. Deere, if you can introduce yourself and go ahead with your testimony.
Thank you very much, Madam Chairman. My name is Brian Deere, and I'm the Executive Director and General Counsel of the National Association of Settlement Purchasers. I appreciate the opportunity to testify this afternoon on House File 3768. NASP is the only trade association representing structured settlement transfer companies. Our membership includes 11 companies which originates structured settlement transfers both here in Minnesota and across the country. For over 25 years, our organization has participated in every state legislature and in Congress to help craft the laws which govern these transactions to ensure adequate consumer protections while permitting these transactions to be available for individuals for whom they are appropriate and valuable. We also provide input to the National Council of Insurance Legislators for periodic updates to the Anquil Model Structured Settlement Protection Act, which serves as the framework for state statutes across the country. In my experience, I've been able to witness both the benefits associated with these transactions for individuals and, unfortunately, the great damage that bad actors in the marketplace can cause if they're left to their own devices. Like many of you, we were deeply troubled by the conduct highlighted in the articles from the Star Tribune last fall. We were also appalled by some of the allegations raised by companies who are not members of our organization and their alleged conduct in Minnesota. We also took note of the comments made by members of the Judiciary that they lack the necessary tools to properly review such cases. We understand that there is an immediate need to update and amend Minnesota's current law for the benefit of structured settlement recipients and are eager to assist in that effort. We've been engaged in constructive dialogue with Representative Koegel and other stakeholders, and we will continue to work with them to provide a better framework in Minnesota for structured settlement transfers. Our goal in these discussions is to make sure that Minnesotans have greater consumer protections in these transactions, to provide the Judiciary with the tools they need to make informed decisions as to whether a proposed transaction is in the best interest of the recipient and their dependents. And perhaps most importantly, to make sure the bad actors in this industry are prevented from taking advantage of Minnesotans, and that Minnesota has the ability to hold bad actors accountable and remove them from the marketplace if they violate the Structured Settlement Protection Act. NASP looks forward to our ongoing discussions with Representative Koegel and other stakeholders on this bill, and I want to thank you all very much for your time, and I'm happy to stick around for any questions if there are any. Thank you very much.
All right, now that winds up our testimony. Thank you everybody for being to the point. We'll move on to member discussion. Representative Johnson.
Chair Becker-Finn, members, Representative Koegel. I think this is a bill that we actually need to do some things with. You can't watch TV at all without seeing at least one particular company advertising continuously. The only thing I have a little bit of a concern on is reading the fiscal note is some of the assumptions made. I'm just wondering if the judge would be able to answer about how many of these court cases we have here and how many attorneys we would need to appoint, and if those attorneys are available to take these cases, because most of them are going to be those that are probably would qualify for a public defender on this issue.
And this is our
Judge Perkio, and I acknowledge that was probably way more than you're able to answer, but to the best that you're able to, if you could answer, Judge Perkio.
I really do not have the actual statistics, and I apologize for that. And I don't know that it would be so much as a public defender situation as it would be more of a panel of attorneys that would be available for appointment. Would seem more appropriate, which is something we've done in the past.
Follow-up, Representative Johnson.
Chair Becker-Finn, Judge Pecco, I appreciate that. I'm just wondering if throughout the state, if we'd have the attorneys available to do this, or if we'd have to figure out a way to get a panel available that would have access throughout the state, because these will come up all over the state, and it could be in every single county. But I agree, we need to do something. I just want to make sure that we have the assets in place when this goes forward.
Response, Representative Koegel.
Thank you, Madam Chair and Representative Johnson. So the independent professional advice could come from, an attorney, a certified public accountant, an actuary, financial advisor, licensed professional advisor, and they would have to. So there's lots of opportunities for folks, you know, it wouldn't just have to be attorneys. It could be somebody who's a professional impartial advisor. And so that was something that we looked at as well.
Right. Thank you for that additional follow-up, Representative Koegel. Representative Scott.
Thank you, Madam Chair. And this question's to the bill's author. Is there peace in the valley on this bill, or is there still more work to do?
Representative Koegel.
Madam Chair and Representative Scott, we're in the same book. We're reading from the same book, just not on the same page yet, but we are getting there. And I think that's been one of the coolest things about this whole process is that everybody sees that it's an issue, and we want to get something done this year.
Follow-up, Representative Scott.
Thank you, Madam Chair. What was the motion? Where's this bill headed, Madam Chair?
It's going to Commerce.
Okay, all right. I just want to make sure there was one more stop for it before, you know, the final, it was settled. Thank you, Madam Chair.
Yep. Thank you, Representative Scott. Much too complicated of a bill for us to get done in just one committee. And I will note for the record that the fiscal note actually reflects that there is no cost as far as we're concerned as a legislature with our budgets. Vice Chair Moller.
Thanks, Madam Chair. And just to piggyback on that, I think if you look at the bill, those costs for the evaluator are paid for by the transferee. So at line 5.12 and 5.13. So the company would pay for that, my understanding.
Thank you, Vice Chair Moller. Always happy to have members reading the bills. With that, members, I don't see any other hands. Representative Koegel, closing comments, and then we'll go to the vote.
Thank you, members, Madam Chair and members. Thank you so much for this this conversation. It's been one that I've been kind of putting my heart and soul and 3 fingers into. So I'm going to see how much I can use that this year. And I think it's been really a great process working with the with everybody at the table to really kind of dive into this, and you know, the people across the street. So I'm really hopeful that we can get something done. And I really want to thank everybody who has put in very hard work, long hours on this bill. And also just wanted to let everybody know that the judges has called us from Puerto Rico. I know she was on vacation, and it was something that was very important to her. And so, you know, I told her that she could testify as long as we got a beach picture. So thank you all. I hope you can support the bill. Thanks.
I apologize. I don't have a beach picture for you right now.
Yeah, it's okay. Well, thank you for taking the time, Judge Perkio. You can get back to your vacation now. With that, I'll renew my motion that House File 3768 be referred to the Commerce Committee. The clerk will take the roll.
Becker-Finn.
Aye.
Moller.
Aye.
Scott.
Aye.
Sorry, I think I froze.
Oh, okay.
Beist.
Aye.
Frazier.
Aye.
Grossel.
Aye.
Herr.
Aye.
Hollins.
Aye.
Johnson.
Aye.
Liebling.
Aye.
Long.
Aye.
Mortensen.
Aye.
Novotny.
Novotny, aye.
Farr.
Aye.
Robbins.
Aye.
Vang.
Aye.
Jean.
Aye.
That is 17 ayes and 0 nays.
All right, the motion prevails and House File 3768 is referred to the Commerce Committee. Thank you, Representative Koegel, and our testifiers. Thank you. Moving right along, House File 3446. Vice Chair Moller, would you like to move your bill?
Thank you, Madam Chair. And I believe that we're moving this to the Human Services, back to the Human Services Committee.
All right, Vice Chair Moller moves that House File 3446 be referred to the Human Services Committee. I also understand there's an A1 amendment. Vice Chair Moller, please move your amendment and let us know what it does.
Thank you, Madam Chair and members. This amendment reflects some stakeholder agreement and discussions and member discussions as well. So it just puts the bill in the shape that I would like, and I would like to move that amendment, Madam Chair. It's the A1.
All right, any discussion to the A1 amendment? Seeing none, all those in favor, please say aye.
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 Opposed? Right, the A1 amendment is adopted. Vice Chair Moller, please tell us about your bill as amended.
Thank you, Madam Chair. Members, this is part of a larger DHS policy bill. And what's before you today does two things. First of all, the bill codifies the home and community-based services critical incident review process, and it also repeals statutes related to trust and medical assistance long-term care eligibility that no longer carry the force of law. The portion dealing with the trust is related to a Minnesota Court of Appeals decision from 2021 that held that federal Medicaid law preempts this statute. And so in light of this ruling, the proposal repeals the statute that was essentially invalidated by the courts. And let's see, the other part of it has to do with home and community-based services critical incident reviews. It's a pilot project known as the HCBS Culture of Safety Project. The project analyzes critical incidents using a safety science lens to enhance accountability by moving beyond blame-based approaches towards approaches identifying how various parts of the system contribute to a critical incident. And just to be clear that it complements but doesn't replace any maltreatment or other criminal or civil investigations that may take place after such an incident. The language in the bill requires that the records used in the reviews remain protected information, and that opinions shared as part of that review are not subject to discovery or introduction into evidence in a civil or criminal action arising out of the review. I want to thank Representative Scott for her work on the amendment and with MinCOGI for the language that they suggested in their input. I actually think we, working together, came up with a better bill, and it made it so that it's not overly broad. And then with me, Madam Chair, is Natasha Mers from the Department of Human Services to provide some more background information.
All right, Natasha Mers, please introduce yourself for the record and go ahead with your testimony.
Thank you very much. Madam Chair, members of the committee, for the record, my name is Natasha Mers, and I am the Director of the Disability Services Division at the Department of Human Services. And I'm here today just to provide a little bit of additional context for culture of safety and why this is an important proposal. So our culture of safety pilot, or the codification of our pilot, uses a safety science approach to understand how systemic influences contribute to negative outcomes for people that use disability services. Sometimes we call these negative outcomes critical incidents. So our current regulatory structure, which is not changed by this proposal, as Representative Moller shared with you a little bit earlier. So the existing regulatory infrastructure exists. Using safety science to do a deeper examination of a critical incident allows us to go deeper and kind of peel that onion back and understand what systemic drivers may be contributing to critical incidents that we see repeatedly throughout our disability services system. So it goes beyond just looking at what the individual direct support professional did or what their provider did, but looking at the system in the whole, which helps us learn and understand what needs to change in our system to avoid critical incidents in the long term. So I just wanted to share one hypothetical example, if I have time to. I think that kind of helps the committee understand what we're trying to do here. So one of the classes of, or the groups of negative critical incidents or negative outcomes that we are analyzing is when a staff member who is supposed to be awake at night caring for someone in a residential setting falls asleep, which is not uncommon. So when that happens, if a negative outcome happened to the person because of that person falling asleep, that incident's going to go through the regulatory process of investigation and potential regulatory citations. But when we map incidents like this, we've learned some key lessons, and these certainly aren't all the lessons, but just some examples of the systemic factors is often people that love and care about that person using services want the most amount of service and protection for that person. So they really are encouraging and asking for staff to be awake at night, even when that may not be fully necessary in the person's service plan based on, how they've been having their nights go for the past year, for example. So we know that that's a factor that we could look at in a different way, understanding from the guardian's perspective or from the family's perspective, why it makes sense to ask for that. Another thing we've learned is that sometimes when staff fall asleep at night when they aren't supposed to be sleeping, that they have been working double shifts because of the staffing shortage. And so they may have already worked a day shift and are hanging on at night because no one else was available and they simply were exhausted. So those two different factors wouldn't necessarily be picked up in a regulatory investigation, but using safety science and critical incident mapping gives us a different window into our system. So I think I'll pause there and see if there's any questions for me. I know you're trying to keep testimony short to get through everyone.
Yep, I appreciate you getting to the point, but I do think it was helpful to have that background, because I know I don't serve on the Human Services Committee, and it's helpful to have someone walk us through exactly what we're talking about. With that, members, I have several people available from DHS if there are questions, so we will move on to discussion. Representative Scott.
Thank you, Madam Chair, and thanks, Representative Moller, for your work on this bill. And to the department, I think it's always good to examine what can be done better. And so I like what you're trying to do with this bill. And I thank you for adding those reporting pieces, because I think that's helpful for the public to see what you're doing and to see, what you're learning as well. So I plan to support this bill today. And thanks again, Representative Moller, for working on it with me. Thank you, and Munkoji.
All right. Not seeing any other hands up. Vice Chair Moller, closing comments.
Just want to thank you, Madam Chair, for hearing this bill, and thank members for their support.
All right, with that, Vice Chair Moller renews her motion to re-refer House File 3446 as amended to the Human Services, Finance and Policy Committee. The clerk will take the roll.
Becker-Finn.
Aye.
Moller.
Aye.
Scott.
Aye.
Feist.
Aye.
Frazier.
Aye.
Counsel.
Aye.
Her.
Aye.
Hollins.
Aye.
Johnson.
Aye.
Liebling.
Aye.
Long.
Aye.
Mortensen.
Aye.
Body aye.
Mortensen, could you repeat yours?
Mortensen, aye.
Thank you. Novotny, aye. Farr.
Farr, aye.
Robbins.
Aye.
Bang.
Aye.
Zhang.
Aye.
That is 17 ayes and 0 nays.
All right, the motion prevails. House File 3446 as amended is re-referred to the Human Services, Finance and Policy Committee. Next up, we have Representative Hollins, House File 3159. Representative Hollins, would you like to move your bill be referred to the Human Services Committee?
Thank you, Madam Chair. Yes, that's my motion.
All right, bill is now before us. I see that you also have an A2 amendment. Representative Hollins, would you like to move your amendment and then tell us about it?
Yes, thank you, Madam Chair. That is my motion.
All right, please go ahead and tell us about the A2.
Okay, the A2 is a fairly simple amendment. What it did is add language to clarify that a consent to adopt with a relative is a valid permanency option that may be considered when a child cannot return home. And language was added to clarify that if a relative is not available to accept placement of the child, the court may then consider permanent placement with a non-relative.
All right, any discussion to the A2 amendment? Seeing none, all those in favor, please say aye.
Aye.
Aye. Opposed? All right, the A2 amendment is adopted. Representative Hollins, please tell us about your bill.
Thank you so much, Madam Chair, and thank you, committee members. This is a bill having to do with the termination of parental rights. I don't know how familiar all of you are with the termination of parental rights, but I want to clarify that this isn't something like custody or parenting time. This is really the most fundamental aspect of our legal relationship with our child. Minnesota statute 260C .513 governs permanency dispositions in child protection cases when a court has determined that a child cannot return home. Currently, the statute states an explicit preference for terminating the parent's legal rights in all permanency decisions before the court may consider other options, like a transfer of permanent custody to a relative. As I said, a termination of parental rights is the permanent legal severing of a parent-child relationship. But it can also unnecessarily sever important relationships the child has with their relatives, friends, and their community in general. This policy is having a disproportionate effect on communities of color. In Minnesota, Native children, Black children, and children with 2 or more races are much more likely to have their parents' rights terminated, but they are less likely than white children to be adopted, leaving higher rates of children of color in foster care without a permanent family. Minnesota is one of only 4 states that has an explicit statutory preference for a termination of parental rights over all other permanency options. So the purpose of this bill is really to ensure that Minnesota's permanency decisions are in line with best practices and keeping families together whenever possible. The bill proposal would eliminate Minnesota's explicit statutory preference for terminating parental rights in permanency dispositions, and instead states that this decision should be based on the best interests of the child according to their unique needs and circumstances. The bill follows widely accepted best practices, as I already stated, and typically that's placing children with relatives and family members before considering options with non-relatives. By removing this statutory preference for terminations of parental rights and making alternative permanency options more accessible, we can help more children exit foster care to permanent families while preserving important relationships and connections to the child's family and community. I believe we have 2 testifiers today, and I will turn it over to them.
All right, thank you. First I have Hannah Burton. Please introduce yourself and go ahead with your testimony.
Thank you, Chair Becker-Finn and members of the committee. My name is Hannah Burton. I'm a student at Mitchell-Hamlin School of Law, where I've been working on this bill with the Institute to Transform Child Protection. But before coming to law school, I was a social worker for about 8 years, working in various child welfare related roles as well. So the purpose of this bill is to make sure that Minnesota's permanency decisions in child protection matters are in line with best practices of maintaining the child's important relationships and connections to their family, their culture, their community, whenever possible. The problem is that under the current law, the explicit preference for a termination of parental rights in permanency decisions creates this unnecessary barrier to considering other options that may be a better fit for the child. And importantly, the current law is lacking clear direction on preferring permanency options with relatives, which we know is in line with best practice because children commonly experience better outcomes when they're placed with their relatives. Social science research shows that children who are placed with relatives experience better behavioral and mental health outcomes, better educational stability, better cultural, racial, and traditional connections to their communities of origin. And importantly, youth report experiencing a greater sense of belonging when placed with relatives and kin. So this bill is really focused on doing all that we can to preserve and expand the children's circle of support at this critical time in their lives, rather than defaulting to a permanency option that can have the effect of shrinking their support system when they need it the most. It may be in certain circumstances that a termination of parental rights is viewed by the court as the best option for the child. And I want to make clear that the bill does not prevent the court from pursuing that if necessary. What this bill does do is 2 important things. First, it removes the presumption that a termination of parental rights is the best option for every child. And instead, it makes transfers of permanent custody, consent to adopt, and termination of parental rights and adoption all equally valid options. And it requires the court to make this decision based on the best interests of the child. And second, it requires that preference be given to permanency options with relatives before considering options with non-relatives. So in closing, this bill is a necessary step in the right direction that will help ensure we're putting our best foot forward for children and their families at a critical decision-making point in the child protection process. Thank you, Chair Becker-Finn and members of the committee for your time, and I'm happy to answer any questions if there are any.
All right, thank you. I do have several other people who are available for questions, but I don't have anyone else signed up to testify. So we'll move on to member discussion. Representative Liebling.
Thank you very much. Let's see if I can get my camera on. There we go. Thank you very much. And I mean, this sounds like a kind of a no-brainer, but the question I have is about ICWA. Is there any interaction with this and ICWA? Because sometimes, I mean, I don't know a ton about this, but you know, sometimes you know, we want ICWA. I think the policy is to keep the child within a tribe, if that's possible. And I don't know, that person may not be a relative, actually. I just wonder if that's been considered with this, and I just want some reassurance that it's not creating a difficulty there.
Well, I can tell you that's kind of an oversimplification of ICWA, and you know, wouldn't supersede ICWA. But Ms. Burton, if you want to comment as well.
Thank you, Madam Chair and Representative, for your question. Chair Becker-Finn is correct. And we also did, though, consult with tribes when we were drafting this language, because we wanted to understand their perspective as well. And this is actually, you know, bringing Minnesota's statute more in line with the common practices under ICWA. But this would not supersede ICWA laws or practices. And I don't have anything further to add on that.
Okay.
Thank you.
Thank you, Madam Chair. And I'm sorry to oversimplify ICWA. I know I don't have I wasn't like prepared, but I just wanted to make sure, and that's comforting to me to know. So thank you.
Yep. Thank you, Representative Liebling. Yeah, it's not as simple as just keeping a child with a tribe. There's a lot more to it than that. Representative Johnson.
Chair Becker-Finn, Representative Hollins. This is an issue that's near and dear to me. As my role as a peace officer, just one summer alone, I dealt with 4 individuals that were minors, 3 young girls going through puberty and a lot of hormone issues, another male young boy that was going through same type of issues. It is important to make sure it's the best interest, not of the family, not of the community, but of the child. What's best for the child? I look at it another way as well. I wish, Representative Hollins, I wish you would have came and talked to me about this bill, because I could give me some great insight, not only from my experience as a peace officer, but I am an adoptee. I understand how adoption works and the importance of adoption. We have, with those individuals I dealt with just that one summer alone, what happened was the biological family got involved. The adopted families had rules. And up until the biological family showed up, things were great in all 3 of those young girls. But the biological family, the siblings, had no rules. They could do whatever they want. They'd show up at 2 o'clock in the morning and text and call these young girls, wake them up, and end up going out in the middle of the night, coming back, oversleeping, not going to school when the family showed up. And that summer alone created havoc, not only for the child that was involved in this, because all 3 of them got into a lot of trouble. They end up in the court system because the biological family showed up. All 3 of these young girls, within a year, ended up pregnant, one by the biological family member. We need to make sure that we are looking not at the best interest of the family, not at the best interest of the adopted person, the adoptees, or where they're being placed. We need to make sure we're in the best interest of that child. I have another family member that was adopted. And The mother and the father were both heavily into drugs, the mother especially, and she was a Native American. The father was not. My relative of the father ended up, his sister ended up getting placed, working with ICWA, and she got permanent adoption. That child needed serious medical attention. Every time he went to the mother's, he'd end up in the hospital again because the mother was not taking proper care of it, and the mother's family was not taking proper care of the child. My wife's relative ended up out of her own pocket paying for basically a life-saving transplant. And that kid is just a bundle of joy to be around. So we have to make sure that when we work with this stuff and work with adoption, the one preference, the only preference we should have is what is the best interest of that child. And with that, I'll leave it there.
All right. Thank you, Representative Johnson. Representative Scott.
Thank you, Madam Chair. And I have a friend, some friends that recently adopted their niece when she was 12 years old. And they went through, I mean, it was a long process. In fact, when this little girl was born, the mom should not have had she should have had her parental rights taken. So this little girl had two older sisters, and kind of the straw that broke the camel's back is that the mom and the oldest daughter got in a knife fight. So all that to say that the mom, before the parental rights were terminated, it was over a year-long process. They would schedule hearings, she wouldn't show up, she got a continuance. It went on and on and on. She was given multiple opportunities. And I need to preface this by saying during that time that the 12-year-old girl was placed with her aunt and uncle that eventually adopted her. And I visited with them about this bill, and her concern was that in situations like that, where you know the parent is most likely not going to be able to ever be able to take care of that child, simply putting them with a family member and not terminating those parental rights and allowing the adoption to take place places that child in a scenario that's kind of like a forever divorce, and they don't have the ability to what they call settle, because they still feel like maybe there's hope that my mom will take me, that I'll go back with my mom. And again, these people were able to adopt this girl, their niece. But if this bill became law, the preference would be to place them with a family member and just transfer legal custody and not make it a permanent situation. So I have issues and concerns about that. And our friends that went through this also had me talk to their guardian ad litem, and their guardian ad litem was concerned about this as well. And so I just encourage caution. I know the intentions are good, and I understand keeping a child around their family, but I think what Representative Johnson said is true, that the best interest of the child has to be above what the best interests of the family are. And I'm not a system making that decision to put a child with a family member just because that's what the law says we should do. So those are my comments, Madam Chair. I won't be able to support the bill today. Again, I realize Representative Hollins, it's well intended. I just have a level of discomfort with it. Thank you.
All right, thank you. I do want to point members to line 1.16 through 1.18. That what we're doing with this bill, just so we're all on the same page to get us back to the bill, is that the preference would be with a relative through an adoption or a transfer of permanent legal and physical custody, or if that is not possible, or in the best interest of the child with a non-relative caregiver through adoption. So I don't think that any of this language is going against the best interest of the child. It's just putting in, giving that relative some say and some acknowledgement in the statute. So just want to make sure that we're sticking to the bill. Not seeing any other hands up. Representative Hollins, any closing comments?
Thank you so much, Madam Chair. And I appreciate the comments that folks have made. I mean, I think we have to recognize that this is a situation where the system always is the one that makes the decision about what the best interest of the child is. And we're just trying to put on even footing options other than a termination of parental rights, right? We're not saying there's a strong preference for one thing or the other, just keeping it all the same. And so with that, I would strongly recommend that you support this, because I think just taking away that presumption alone gives our judicial system a lot more leeway to be able to look at what's best for the child, and honestly look at what is best for the child and be able to make that decision more accurately. So thank you so much. I ask for your support.
All right. Representative Hollins renews her motion that House File 3159 as amended be referred to the Human Services Finance and Policy Committee. The clerk will take the roll.
Becker-Finn,
Aye.
Moller,
Aye.
Scott,
No.
Feist,
Aye.
Frazier,
Aye.
Grossel,
No.
Her,
Aye.
Hollins,
Aye.
Johnson,
No.
Liebling,
Aye.
Long,
Aye.
Mortensen,
Mortensen, no.
Novotny,
Aye, no.
Farr,
Or no.
Robbins,
No.
Bang,
Aye.
Zhang.
Aye.
That is 10 ayes and 7 nays.
All right, the motion prevails. The bill is on its way to Human Services. Thank you, Representative Hollins and Ms. Burton. With that, members, I am going to hand the virtual gavel over to Vice Chair Moller for the next two bills. So it's officially in your hands, Vice Chair Moller.
Thank you, Madam Chair. So members, the next bill before us is Chair Becker-Finn's House File 3135. Chair Becker-Finn, would you like to move that House File 3135 be laid over for possible inclusion in the omnibus bill?
Yes, Madam Chair, that is my motion. And then while I am already speaking, I will move the A3 amendment, kind of a pure author's amendment, just clarifying some things that we didn't catch before the bill was introduced. So I would move the A3 amendment to 3135.
Okay, any discussion to the amendment? Members, please unmute yourself. All those in favor say aye.
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 Opposed? The motion prevails and the amendment is adopted to your amended bill, Chair Becker-Finn.
All right, thank you, Madam Chair. So if members remember last year, we passed legislation to make it so that parents have counsel in child protection hearings. And so this is sort of phase 2 of those efforts in making sure that parents who need counsel have counsel. So this is pretty straightforward in that we're establishing a state board of appellate counsel for parents to provide representation to eligible parents at the appellate level in juvenile protection matters. So that's the really simple summary of the bill. And with that, we'll cede more of my time to my testifiers, Madam Chair.
Thank you. So the first testifier is Brooke Beskow-Warg. If you are, I see you turned your camera on. Welcome to the committee. Please introduce yourself and you can begin your testimony.
Thank you, Madam Chair, Representative Becker-Finn, and members of the committee. My name is Brooke Beskow-Warg, and I am an attorney and Equal Justice Works Fellow with the Institute to Transform Child Protection at Mitchell-Hamlin School of Law. Thank you for having me here today. Beginning in 2023, low-income parents in child protection matters have a right to court-appointed counsel at all stages of the proceedings, including through appeal. The right to appeal is critical for ensuring due process for families involved in child protection cases. However, that right is meaningless without available, accessible, and qualified attorneys. Minnesota does not currently have a consistent statewide process for appointing appellate counsel in child protection proceedings. The state also lacks a list of qualified appellate counsel from which to assign appeals. This means that families are unable to effectively challenge district court rulings following a termination of parental rights and advocate for the right to remain together. Parents and families are not the only parties with a direct interest in accurate outcomes. The child protection system as a whole and all of those involved in it have an interest in accurate and just proceedings. An effective appellate system helps ensure fair and accurate decisions in individual cases. An effective appellate system also ensures proper application of child protection law, which impacts the system as a whole. When incorrect or improper decisions are made in these important cases, families suffer. Notably, many of the families involved in the child protection system in Minnesota are experiencing poverty. In addition, American Indian, Black, Hispanic, and children of 2 or more races in Minnesota are statistically more likely to enter foster care and have their parents' rights terminated, and are less likely than their white peers to be adopted. The lack of access to an appeal both creates and aggravates these disparities in the system. Importantly, this bill provides that the office would work collaboratively with sovereign tribal nations in the state and also include attorneys who practice in tribal court. The Office of Appellate Counsel for Parents would implement a consistent statewide system for appointing counsel on appeal. This would in turn ensure that parents' rights are protected, it would reduce racial disparities, and it would improve the child protection system as a whole. I'm happy to answer any questions, and Joanna Woolman from the Institute to Transform Child Protection is also here to answer any questions. Thank you.
Thank you so much. Wow, Mitchell Hamlin's really bringing it tonight. We appreciate all the testifiers here. The next testifier is Mallory Stoll. Go ahead and introduce yourself and begin your testimony.
Thank you, Vice Chair Moller. Thank you, Chair Becker-Finn. Good evening, committee members. My name is Mallory Stoll. I am an attorney that is in private practice, and I represent clients in family court as well as juvenile court or child protection matters. Specifically, I have served as court-appointed counsel for parents and relatives in the child protection process in the 1st, 3rd, and 10th judicial districts, all the way beginning with district court representation, all the way up to the Minnesota Supreme Court twice last term. The majority of my work in child protection starts with me being appointed to further, or I guess, realize parents' rights to court-appointed counsel in these proceedings. I've been in the role of serving as the appellate counsel, and that's my first experience with the case. I've also had cases that I have seen all the way from the district court level, all the way to the Minnesota Supreme Court. The reason why I am testifying in support of this bill is, given my experience throughout the metro area, greater Minnesota, I see a significant disparity in how appellate counsel is ultimately appointed. We have very short timelines in child protection matters to appeal. You have 10 days from the date that the notice of filing of order is received to file what's called a motion or new trial. You only have 20 days to file the notice of appeal. If you miss day 20, the appellate court does not have jurisdiction to hear that appeal. And unfortunately, I know of at least one case where that has happened. Given these short timelines, by not having these consistent policies, I have sometimes been appointed day 8, day 9, day 10. And by not being able to file a motion for amended findings in a timely manner, it significantly reduces what issues I can raise on appeal. Given that we do have a short amount of time, I just want to conclude my remarks with saying that, in these cases, we're dealing with fundamental rights to parent. As court-appointed counsel, I've had some cases have been affirmed on appeal. I've also secured several reversals, which shows just how important this work is, and the importance of having qualified appellate counsel to ensure that families are able to stay together whenever possible and that the laws are followed. So I certainly welcome any questions that anyone may have for me, and thank you for your time.
Thank you so much. And as somebody mentioned, we have Professor Woolman here just to answer questions, and we will move on now to member questions. Not seeing any hands raised. So Chair Becker-Finn, closing comments.
Yeah, thank you, Vice Chair Moller, and I want to thank our testifiers. I think they did a good job of summarizing why this is important and how it's always great to have practitioners who actually do this work here to share their perspective. And so we do have support in the Senate as well, and we're hopeful we can move this forward this year. So just thank members for their support.
And with that, House File 3135 as amended is laid over for possible inclusion in an omnibus bill. Our next bill is also another Chair Becker-Finn bill, House File 3761. Chair Becker-Finn, would you like to move your bill?
Yes, Madam Chair, I would move House File 3761. And to be clear, I think I got this wrong when I was talking to staff. So my motion would be to send this back to the Environment and Natural Resources Committee.
All right, very well. And it doesn't look like you have any amendment to the bill. So if you want to go ahead and describe your bill, please.
Yep. Thank you, Madam Chair, and taking us in a very different direction from child protection. Members, this is a bill about protecting our water. Water is the lifeblood of our planet, and we don't exist without it. And I personally take my responsibility to protect it really seriously. House File 3761 provides the Department of Natural Resources additional tools for enforcement and compliance in relation to water permits. So a water appropriation permit is not a right. It is not a carte blanche permission for a user to do whatever they want. It's a privilege, and honestly, a permit is a contract. The state agrees to allow the use of a public natural resource, and in return, the permit holder agrees to abide by what the permit specifically allows. So adding these enforcement tools will help prevent the violation of permits in the first place, which I think we can all agree should be the goal. Ultimately, this is really to hold sort of, we have a lot of bills where we talk about bad actors. Well, occasionally we have folks who willfully don't follow the law as far as their permits are concerned. And so this bill makes clear what the consequences could be, and if there's a failure to hold up your side of the contract. And so it is here in this committee because of those additional enforcement and civil penalties that would be possible. So that is why it is here with our committee. And with that, I will turn it over to my testifier from the DNR, Katie Smith.
All right, welcome to the committee. Ms. Smith, please introduce yourself and begin your testimony.
Madam Chair, committee members, good evening. My name is Katie Smith. I'm the Director of Ecological and Water Resources at the Minnesota Department of Natural Resources. The DNR plays an important role in ensuring there is a sustainable water supply available in Minnesota, and compliance with the state's water laws and permit programs is necessary to protect natural resources and ensure the best use of Minnesota's water resources. So non-compliance with water laws, particularly in times of drought, threaten the sustainability. DNR's existing enforcement authorities are insufficient to address serious or repeat violations of state water laws. Changes to DNR's existing authorities would help us to ensure our water supply is protected and hold violators accountable using a variety of compliance tools. The language contained in this bill is very similar to statutes governing the MPCA's tools and authorities. The DNR has existing authority to issue administrative penalty orders, or APOs, for water appropriation. The proposal would give DNR greater discretion for calculating penalties, increase the APO cap to $40,000, and require penalties to be paid for violations that are serious or repeat. However, no changes are being proposed to the appeal section. The APO is a valuable tool, but it can only be used in certain types of situations. Other compliance tools would give DNR new authority to utilize actions to compel performance, one being a stipulation agreement, which is a negotiated settlement agreement that is not limited by a maximum penalty amount nor a corrective action timeframe, and provides for a negotiated settlement with the violator. For the most serious violations, such as those that may harm or have harmed natural resources, repeated violations, or where economic benefit was gained, DNR is seeking authority to assess civil penalties of up to $10,000 per day of violation. The language allows for the penalty amount to be determined by the court. Civil penalties and damages provided for in that subdivision may be recovered by a civil action brought by the Attorney General in the name of the state in Ramsey County District Court. Civil penalties and damages provided for in the subdivision may also be resolved by the Commissioner through a negotiated stipulation agreement between the DNR and a party. It's anticipated that the stipulation agreement would be the process and tool to assess and recover penalties under this chapter. The chapter tools and permits issued under this chapter may be enforced through several ways. The bill allows for willful or negligent violations of these water programs to be referred by DNR to law enforcement agencies for investigation. A violation of this chapter, orders or agreements and permits issued under this chapter constitutes a public nuisance and may be enjoined in an action in the name of the state brought by the Attorney General. In an action to compel performance of an order issued by the Commissioner, the court may require a defendant to perform any and all acts within the defendant's power that are reasonably necessary to accomplish the purposes of the order. The DNR would not seek court assistance unless the party does not respond to the order and all other options have been exhausted. If a municipality is a defendant, the court may require the municipality to exercise its powers in order to pay a penalty or perform corrective actions, but it leaves that local unit of government the discretion regarding how it will obtain funds to comply with the court's order. An action brought under this subdivision will be venued in Ramsey County District Court. The DNR feels these enhancements of authorities and tools would help ensure our water resources are protected and available for future generations of Minnesotans. Thanks for the opportunity to testify today.
Thank you. And it looks like we have one other testifier who signed up. Jake Wildman, please introduce yourself. Welcome to the committee, and you can begin.
Thank you, Madam Chair and members of the committee. I appreciate the opportunity to testify this evening. My name is Jake Wildman, and I'm the president of the Irrigators Association of Minnesota. My family and I farm near Glenwood, Minnesota, in west central part of the state, where we raise corn, soybeans, peas, sweet corn, wheat, and canola. We also incorporate cover crops on as many acres as possible every year. About 75% of our crops are irrigated. Just a little background of our operation. In regards to House File 3761, we are still reviewing the impact of this bill that would have on our members of our association, but I just wanted to point out a few areas of concern. First, in regards to Section 1, the DNR basically has the authority to do a lot of the things that are mentioned in the section. For example, there have been numerous situations where in order for a grower to receive his or her permit, they must install monitoring wells, perform an aquifer test, and report their findings back to the DNR. If they don't do this, it's most likely the permit will not be issued. And also just the costs associated with the monitoring equipment and other testing methods are a concern for us as well. As permit holders, 100% of these costs are on us without any cost share opportunities available from the department. In Section 4, there's some concern of the deletion of the minor, moderate, and severe language and the subsequent caps, and the language being replaced with up to a $40,000 penalty. I see that number, and as a young farmer, this is a lot of money for my operation. And finally, Madam Chair, my last concern is in Section 6, Subdivision 2, which would allow for criminal prosecution for a possible violation of a permit, as well as fines up to $10,000 per day. For multiple reasons, Madam Chair, this is a concern for myself and our members. As an association, I just want to be on record saying we do not support individuals who use groundwater without a permit, and not-permitted users should be penalized. But a major concern is that even for a minor violation, a permit holder could result in substantial financial costs and criminal prosecution from the language within this bill. Again, thank you for allowing me to testify and point out these concerns, and we will continue to analyze the legislation and its impact on our members. Thank you again.
Thanks for your testimony. Chair Becker-Finn, would you like to respond before we move to member questions?
Yeah, one thing I want to make sure I point out is in the penalty section that if the violation has been corrected or appropriate steps have been taken to correct the action, the penalty must be forgiven. It's not a may be forgiven, it's a must be forgiven. What we're trying to get at here is actors who violate their permits and then are not motivated by the current tools that we have to change their behaviors. So that is what we're trying to get at here. Obviously, it is not intended to provide extra burdens for those who are already following the rules. Thank you, Madam Chair.
Moving on to member questions, Representative Scott.
Thanks, Madam Chair. And Chair Becker-Finn, just curious why Ramsey County is chosen as the venue that these cases have to be heard there. Usually when there's a harm done, isn't it done more at the county courthouse, closest to where the event took place?
Chair Becker-Finn.
The DNR offices are in Ramsey County, so that's why that provision is there.
Representative Scott.
Madam Chair, but why can't the DNR go to where the action took place, the violation?
Chair Becker-Finn.
This was the choice that we made in this bill. Obviously, folks can disagree with that if they want. I'm not sure if Ms. Smith wants to comment further to the choice to venue in Ramsey County.
Ms. Smith.
Madam Chair, committee members, generally actions have been venued in Ramsey Court. If there were a particular situation, in my experience where, say, an administrative penalty order was issued in Greater Minnesota, there have been situations where, say, a hearing would take place in a local venue, but for this particular subdivision, we chose Ramsey County, just as Representative Becker-Finn said, because that's where the DNR office is located.
Representative Scott.
Thank you, Madam Chair.
Any other questions? All right, Chair Becker-Finn, any closing comments?
I just appreciate members' support and glad we can raise up this issue and move it forward. With that, I will renew my motion that House File 3761 be referred to the Environment and Natural Resources Committee.
All right, the clerk will take the roll.
Becker-Finn.
Aye.
Moller.
Aye.
Scott.
No.
Feist.
Aye.
Frazier.
Aye.
Counsel.
Nope.
Her.
Aye.
Hollins. Hollins.
Aye.
Johnson.
No.
Liebling.
Aye.
Long.
Aye.
Mortensen.
Mortensen, no.
Novotny.
Novotny, no.
Barr.
Barr, no.
Robbins.
No.
Bang.
Aye.
Zhang.
Aye.
That is 10 ayes and 7 nays.
The motion prevails and House File 3761 is on its way to the Environment and Natural Resources Committee, and it's back to you, Chair Becker-Finn.
Right. Thank you, Vice Chair Moller. With that, moving right along, members, the next bill on our agenda is House File 3850, a Representative Thompson bill. I will move House File 3850 in front of us. The plan is that we will be laying this over for possible inclusion. Representative Thompson, please tell us about your bill.
Thank you, Chair Becker-Finn. That's exactly what I'm trying to do, is ask you guys to lay this over. This bill is relating to state government establishing the Minnesota Migration Act, appropriating money to study and develop reparation proposals for American descendants of chattel slavery. By no means is this bill meant to cause anybody's, because this is a very, it seems like it's controversial, but it's overdue. This conversation is way overdue. And so that was my ask, Chair, to have this bill included for consideration.
All right. Thank you, Representative Thompson. We do have a lot of testifiers, and just so all the testifiers are aware, everybody's going to get 2 minutes. I made the decision that it was more important to hear more voices instead of letting a single person eat up all the time. So we are going to time you, and no disrespect is meant. It's actually out of respect to your fellow testifiers that we're going to keep everybody to 2 minutes. The first, yeah, Representative Thompson.
Chair, with all due respect, you're absolutely right. I just had the keys to the car, and this is totally driven by community. And so, yes, thank you.
All right, thank you, Representative Thompson. First on the list, I have Reverend Ronnie Patterson. Please introduce yourself for the record and go ahead with your testimony.
Uh-oh.
We can move to the next person on the list and we'll come back to that person. Reverend Spence, if you're here, if you can introduce yourself and go ahead with your testimony. All right, I see Trahern Cruz has his camera on, so we'll go to you next. If you can introduce yourself for the record and then go ahead with your testimony, please.
Hello, I'm Trahern Cruz. I'm a St. Paul resident and part of the St. Paul Recovery Act Legislative Advisory Committee that focuses on reparations for the city of St. Paul that was passed January 13th, 2021. I have just a quick statement to read. Black Minnesotans have contributed greatly to the state of Minnesota. In the United States, Casville Bullard helped build the Minnesota State Capitol. Likewise, and other Black Americans, likewise, 300 enslaved Black Americans built the nation's capital, but were never paid. According to Demos, the racial wealth gap is substantial and is driven by public policy. Minnesota has some of the worst disparities in the nations as it pertains to housing. Home ownership is the path to creating generational wealth. White Americans have $100 trillion worth of wealth. Black Americans have $2.6 trillion worth of wealth. And again, the racial wealth gap is substantial and is driven by public policy. Some examples of public policy are racial covenants, which were here in Minnesota for a very long time. 3 strikes and you're out, slavery, the lynching period, and many others. The New England Journal of Medicine said if reparations were in place, the Black community would not have been impacted by COVID-19 as severely as we were. And we believe that reparations, as the New England Journal of Medicine believes that the reparations is the quickest and most efficient ways to close the racial wealth gap and the disparities in health, housing, employment, and the rest of the disparities that impact Black people's lives. So I think I think this is a really great bill and is a pathway to closing the racial wealth gap and starting healing in America. Thank you.
All right, thank you for your testimony. Next on the list, I have Minister Toya. If you can unmute yourself, introduce yourself for the record, and then go ahead with your testimony.
I'm Minister Toya Woodland. I'm with ICIL Ministries, also St. Paul Recovery Act Steering Committee here in St. Paul. So my thing is that we suffer here in Minnesota by being the lowest of everything. Right now, the median income for an average Black family here in the state of Minnesota is $15,200, while the median income for the average white family here in Minnesota is $60,000 annually. Also, we represent 13% of the population, yet we make up 53% of all children that are removed by CPS. We also, one in every 4 Black women here in Minnesota that go through labor and delivery, 1 in 4 die during labor and delivery. We face some of the biggest disparities here in Minnesota. We face some of the lowest income and highest unemployment and highest rates of lowest rates in housing, home ownership. We are hoping that the Minnesota Migration Act will address some of those disparities that we are currently facing in health, family, reconciliation, and financial difficulties that we suffer here in Minnesota. And today we're just asking that it be considered here in this hearing. Thank you. Have a great day.
Yeah, thank you for your testimony. Next on the list, I have Jane Prince. If you can introduce yourself for the record and go ahead with your testimony.
Muted.
Yes, I'm Jane Prince, and I serve on the St. Paul City Council. Thanks to the members of the House Judiciary, Finance, and Civil Law Committee for considering this important and groundbreaking legislation. As mentioned, the City of St. Paul passed the St. Paul Recovery Act and Community Reparations Resolution in January of 21. By way of that resolution, the City Council made formal apology for the specific ways in which African-American people in our city have been discriminated against, including through real estate redlining, racial covenants on housing deeds, and most significantly, in the destruction of St. Paul's vibrant and growing Black middle-class neighborhood and 300 business district, which was bulldozed to make way for Interstate 94 in the 50s. Like Evanston, Illinois, St. Paul's resolution will lead to the creation of a reparations commission, which will be appointed in 2023 to address disparities resulting from city policies and ordinances over the past 50 years. My ancestors did not own slaves, but my family did benefit from an unfair system that raised up people who look like me and held back the hopes and dreams of African Americans. My dad was a US Army infantry fighter in terrible combat in the Pacific in World War II. When he came home after the war, he and my mom were able to use the GI Bill to build a home, to raise my brother, sister, and I, which went on to provide home equity loans to send us to college and launch my successful life. For African-American GIs returning from the same combat, the GI Bill was meaningless. They were unable to get bank loans and mortgages to go to school and buy homes for their new and growing families. Generational wealth that fell to me and my family was not available to that entire generation of Black veterans with the same benefits. For another source of support for this bill, I have put in the link that Mr. Cruz referred to from the New England Journal of Medicine, stating that reparations is ultimately the best way to close the racial health gap that has led to all the other Black-white disparities in housing, education, fair wages, and safe workplaces. Please support this bill. Thank you.
All right, thank you for your testimony. Next, I have Delshia Perry. If you can introduce yourself and go ahead with your testimony.
Thank you, Madam Chair and the committee members, especially Representative John Thompson, for the work that you have done and have continued to do. I'm so grateful for Trayon Cruz, who's been working diligently with reparations. I just want to talk real quick about the health and wellness piece. As you all know, my name is Delshia Perry. I am the president and founder of Be Their Voices. Many of you have heard my story and why I started this organization. But what I wanted to talk about tonight was the health and wellness and the disparities in that area. And I believe that there should be a certain percentage of professional Black healthcare providers, not just in Minnesota, but of course in our jails. Because if that had been the case when my son was in custody, we may not be talking about Hardell Sherrill, a case of Naja Khan Powell, a case of Amity Dimmick with Kobe Heisler. So I just believe that with all of the disparities in the Black community, we certainly must do something about the health and wellness of Black individuals in the state of Minnesota, and not just continue to talk about it, but to be about it. And I know that John Thompson is doing an amazing job, and I just take my hat off to you for the work that you're doing. And I just wanted to say thank you, everyone, for coming on and allowing me the opportunity to express my thank yous for the work that everyone is doing. And I certainly hope that you all will take this into serious consideration and give this bill the passage that it needs to move forward, because we certainly need all the help that we can get. And as Representative John Thompson said, this conversation is well overdue. So thank you again for your time this evening. I thank you all. God bless you. Thank you.
Thank you for your testimony. Next on the list, I have Pamela Gojeri. Hopefully I said that right. Please introduce yourself for the record and go ahead with your testimony.
Good evening. My name is Reverend Pamela Gojiri. I am one of the co-directors for racial justice here at the Minnesota Council of Churches. The Minnesota Council of Churches is a premier statewide council constituted by its 27-member historical Black church, mainline Protestant, Pentecostal, and Orthodox judicatories, representing about 1 million members. Our mission is to manifest the unity in the body of Christ and to build a common good in the world. The rationale for our work presupposes that an organization with our membership and strong interfaith partners is well situated to lead the envisioned process for change. Much of the work is on a larger scale beyond what an individual denomination could address on their own. After the murder of George Floyd, amidst the racial unrest that gripped the Twin Cities, the board of MCC began a deep conversation asking what the church must do to be about the work of healing and repair. This led to the creation of our 3-tier truth, education, and reparations program. Truth telling is the sharing of stories of harm from the Native American and African American communities with white congregations to begin the process of breaking down the myths and lies that are put forward about Natives and Blacks. Education is the participation of congregations in programming that continues breaking down stereotypes and misinformation. Reparations is the work of repairing the harm caused by systemic racism, as there has never been an equitable relationship between dominant white culture and Native and Black folks in this country. The playing field has never been level. These two communities are the foundation of the ongoing racism that affects other people groups here in this country. We have to start at the beginning and de-root the problem. If these two groups are humanized, the rest of the BIPOC communities will reap the benefits of this change as well. Reparations is what should have been given after slavery ended and what should have been honored by the treaties that the government made with the Native Americans in this country in preparation for success in their new lives, new status, and with their new citizenship. We at MCC support the intent of the Minnesota Migration Act, which aligns with our work, and we will walk alongside the partners in this ongoing process. Thank you very much.
Thank you for your testimony. Next on the list, I have Jeremy English. Please introduce yourself for the record and go ahead with your testimony.
Hello, committee. Thank you for having me. Thank you, Chair. Thank you, Chairman Becker-Finn. Thank you, Vice Chair Moller. And I kind of want to just talk about a little bit about the committee piece of the Migration Act, because that's one of the most beautiful pieces of it. And I can kind of give you kind of a diagram by kind of describing the St. Paul Recovery Act. I am a steering committee member of the St. Paul Recovery Act. And basically, the council resolution calls for the creation of a limited legislative advisory committee, which will work with the city administration to create a framework in the city codes for a permanent commission to be known as the St. Paul Recovery Act Reparations Commission. The commission will be empowered to make short, medium, long-term recommendations specifically to address the creation of generational wealth for Black Americans, descendants of chattel slavery, to boost economic mobility and opportunity in the Black community. Well, when you look at the Migration Act, it is kind of some of the same framework. The steering committee shall issue a written report of the steering committee's findings and make recommendations to the legislative committee with jurisdiction over human rights to identify the form of compensation that should be awarded and the mechanisms through which it should be dispersed, and those persons who should be eligible for the compensation. So when you look at HF number 3850, it really is a great committee and a great step that the state could take to acknowledge that they are ready to make a historical move forward in regards to studying reparations for Black Americans and kind of repairing some of those issues that we've had on a state level. Thank you.
All right, thank you for your testimony. Next, I have Nick Muhammad. Please introduce yourself for the record and go ahead with your testimony.
Thank you, Madam Chair, and the rest of the council here.
Primarily, I'm asking you all to support HF House File 3850, shortly put in light of everything that everybody's already put on the table as far as the data. Reparations is essential to the practice of eliminating racial disparities in the state of Minnesota. We already know that the current trajectory that we're on pertaining to the American descendants of chattel slavery is not maintainable, and the historical context is grossly misunderstood by many, which helps us to continue to kick the can down the road, and we continue to misunderstand what we're dealing with. Now, this bill is needed to establish not only the historical context, but the impact of the politically fortified systemic racism embodied in our current disparities. But it's also the process of which to establish resources so that we can actually forge a pathway forward in addressing these things in a long-term solution. Now, due to the practice of these historical narratives and suppressing the actual true historical context, the racial impetus in the context of many of the federal, state, and municipal laws and ordinances are critically misunderstood. And as far as their impact on our community, people don't understand why we have certain outcomes in the Black community or the ADOS community as opposed to some of our counterparts. That context is embedded inside of the process of reparations. The historical context of the crime that's happened to the Black community is grossly misunderstood. And that's why I want you all to support the House File 3850 moving forward, because right now we're on a trajectory where the median household income of the average Black family in the country and the state of Minnesota is projected to be zero. We already have a 95.4% per capita homeless rate inside of the Black community, where everybody else is under 30%. This is simply not maintainable. And we've already ran down the data on home ownership, which is a catalyst for wealth creation in any community. And we haven't even touched on the lack of critical business infrastructure in industry in order to be able to hire and pay our own eligible workforce. Now, these are things that the state of Minnesota is in a great position to actually wrestle with, but we just have to take the political will and fortitude to move studies like this forward so that we can actually establish the historical context and how deep the well goes, and more importantly, what we're going to need in order to begin to address it. Back to you, Madam Chair.
All right, thank you very much for your testimony. Next up, I have Ben Imchi. If you can introduce yourself for the record and go ahead with your testimony.
For the record, the name is Ben Mackay. Thank you, Madam Chair, for this opportunity to speak on behalf of House File 3850. Again, my name is Benjamin Mackay. I'm an educational consultant, and I work on curriculum reform applied to teacher candidates to build a stronger workforce in that hallowed profession. The departments that I have worked with are at the University of St. Thomas and also Metro State University School of Urban Education. We are currently working in Minnesota State College's Southeast in Goodhue and Wabasha County. I am also a member of the Reparations Advisory Committee for the City of St. Paul. The Minnesota racial wealth gap is driven by public policy. Wealth defined as the net worth of a person, the total value of assets minus liabilities. State of Minnesota has the third worst racial wealth gap in America. The racial wealth gap did not become a reality because of lack of labor. Instead, it is coming from a lack of financial capital. Income is the amount of money that a person receives in return for their services, sales, and goods, or profit from investment. Now, a recession, we've had two of them this century, impacts everyone, but wealth is distributed so unevenly in Minnesota that Mr. Muhammad's testimony speaks to the kind of numbers that the African-American community is dealing with. The lack of government-sponsored safety nets was apparent in the wake of the economic disaster like the 2008 housing crisis, or a natural disaster, such as Hurricane Katrina in 2005. With COVID and the Eastern European conflict in front of us right now, causing inflation, another downturn is entirely possible. The advisory committee that I sit on discusses, among other things, reparations allocations ranging from down payment housing revitalization grants to student loan forgiveness for qualified descendants of American chattel slavery. Redress focuses on investment, not expense. As former Senator Wellstone said, when we all do better, we all do better. Please consider House File 3850 to pass and make its way through committees to reach the governor's desk. Thank you very much for your time today.
Thank you, Mr. Mackay, and I apologize for mispronouncing your name the first time. Next up, I have Professor Andy Johnson. Please introduce yourself for the record and go ahead with your testimony.
Thank you, Madam Chair. My name is Dr. Andy Johnson. I teach cross-cultural psychology and motivation classes at Bethel University. My students have been involved in project-based learning experiences regarding homelessness, poverty, interpersonal violence, and other issues in the Frogtown Summit University neighborhoods over the past several years. In recent projects over the past 2 years related to income and housing, my students and I have discovered some very unsettling information, much of which has been covered by my colleagues here. I'm going to limit my comments to the racial wealth gap. The racial wealth gap is substantial and persistent over time, rooted in a history of systematic oppression and inequality. On the national level, the median income for whites in the states is several times higher than the median income for people of African ancestry, African Americans. We see negative effects, as many have noted, even in the state of Minnesota. For example, according to the U.S. Census Bureau, St. Paul per capita income for the 5-year period beginning in 2013 is less than $16,000 on average for African Americans in comparison to over $42,000 for whites. St. Paul home ownership for the same 5-year period is under 17% for African Americans in comparison to over 61% for whites. I want to make it clear that once we started the project, there was one group of students involved, and they were looking at the issue of reparations, and they thought, well, this is such a controversial thing. We need to prepare a project on how can we motivate people to even become involved in the discussion. And what they found, in contrast to other projects that other students were doing on other problems, is just when people become aware of the statistics and the severe nature of the wealth gap, that's really all motivation that they needed. And they were very surprised at how willing people were to discuss these issues. But in short, something needs to be done. The Minnesota Migration Act sets aside funds for systematic exploration of the problem. Now, Jones and McElderry last year published an article saying that there are 2 basic reasons that have been used to pursue reparations. The first one is the idea that responsible entities have a legal obligation to remedy past harms. The second is that there's a moral obligation to address injustices rooted in slavery, lynching, redlining, and other atrocities. And I would add that there's emerging evidence, research evidence, that suggests a third reason in addition to those noted by Jones and McElderry, and that is the issue of effectiveness. Peters, in an article in February of this year, reports on the results of pilot studies in Vancouver and places ranging from Newark, New Jersey to Chicago that show that cash payments have a surprising effect, and sometimes very modest cash payments have a surprising positive effect on addressing homelessness and can do so more effectively than standard procedures in place.
Mr. Johnson, I'm going to have to ask you to wrap up.
Okay, in conclusion, although Minnesota was a leader at one time, we're not in a leadership position in terms of addressing the racial wealth gap at present. Collecting evidence to guide future policies to reduce the racial wealth and other disparities is needed, and I personally support HF 3850 as a step forward in this process. Thank you, Madam Chair.
Thank you, Professor Johnson. Next, I have Professor Tandon Brecky. Please introduce yourself and go ahead with your testimony.
Thank you, Madam Chair, and other members of the committee. My name is Dr. Tanner Brecky. I'm an associate professor and Assistant Director for Service Learning and Community Engagement at Bethel University. I've had the joy of doing university community partnership work or developing university and community partnerships for the last 15 years. And about a year and a half ago, one of our community partners, the Community Stabilization Project, said, hey, there's some really beautiful work happening with the St. Paul Recovery Act. You need to learn more about it. And when community partners tell me that, I'm like, okay, I got to key into that beautiful work. And so we started connecting with Traherne Cruz and Council Member Prince at that time, and learned more about what the beautiful work that's happening with the St. Paul Recovery Act. And over the last year, we've got students and faculty connected on that project. And then we'll continue working with the Minnesota Migration Act. There's two things I want to emphasize here with this kind of work that I think is crucial, that I've learned and connected with my faculty and the students that I work with. One is the meaningfulness of this work. The students the emerging leaders, the way I would like to refer to our students, they realize that we have issues, serious issues around racial inequality. And they realize that we can't just keep addressing the symptoms. We have to go to the core of the issue. And the students that I've got connected to this kind of work see that this work is connecting to the core of what's happening, what has happened and what's currently happening. So it's meaningful in the sense that it's going to address the core. And that's been already addressed, why that's the core by my esteemed colleagues. The other piece for us, I work at a religious institution, specifically Christian. I'm a trained Christian pastor, and our religious tradition teaches us that the wrongs or the sins have to be dealt with in a way that actually acknowledges them and does some repair to address those harms. Sin doesn't just evaporate. It's only dealt with when we repent and change our behavior. And the students and faculty that I work with identify this work closely with their religious convictions. And so I bring that knowledge to us today, that religion reminds us that we must confess what's happened and then take concrete action. And I would say that this bill is a significant step along that journey. So thank you.
All right, thank you for your testimony. That wraps up our testimony. I want to thank all the testifiers and really appreciate everybody. I didn't really have to cut anybody off, and really appreciate folks being respectful of each other with their testimony today. With that, members, we'll move to member discussion. Representative Scott.
Thank you, Madam Chair. I had a couple of questions. Representative Thompson, I only found in a search online, the only thing I found on the Minnesota Migration Act was on Facebook. And so would you be able to elaborate a little bit more about that? I just couldn't find much information on it, its mission, all that stuff. How many people, how many members are there? So anything that you could tell me about that organization would be great.
Representative Thompson, do you want me to go to Mr. Cruz? It looks like he's prepared to answer that. Okay, Mr. Cruz, please go ahead.
So this Minnesota Migration Act is an extension of the St. Paul Recovery Act, and the St. Paul Recovery Act had a steering committee that did the work of organizing, going out, talking to the community members, educating people about what reparations is, holding like business informational about it, doing surveys, getting community members and business owners to sign on to a letter of support, and actually wrote with Councilmember Prince wrote the St. Paul Recovery Act resolution and did the work of getting it passed. So that would be the same model for the Minnesota Migration Act.
Representative Scott.
Thank you, Madam Chair. So is the Minnesota Migration Act, is that a 501(c)(3)? Is it a nonprofit? Or do you have a organizational affiliation like that, or?
We would be
Mr.
through,
Cruz.
oops, excuse me, I'm sorry.
No, it's all right. Go ahead, Mr. Cruz.
We will work, the organization that we will work through with that is called Secrets to Truth, and it's operated by Maria Perry, but she was having trouble getting on the call tonight.
Representative Scott, and I'll remind folks too, we're laying this over, so if there's kind of details that need to be worked out, we have the ability to do that. Representative Scott.
Thank you, Madam Chair. So secrets for truth, secrets to truth.
Yeah.
I'm sorry, I didn't catch that.
Secrets
Mr.
to
Cruz.
Truth. Sorry about that. Secrets to Truth would be the organization that would be like the fiscal sponsor for the Minnesota Migration Act.
Okay.
Representative Scott.
Thank you, Madam Chair. And so I noticed, Representative Thompson, in the bill that they're going to be doing this work, and they're asking for $2 million to do the work and then put out a report. I don't know if there's precedent for that in statute where we give an organization that's not like a 501(c)(3), a nonprofit, that sort of thing, where we give them funds to do something like this. I don't know if that's been done before. How did you arrive at the $2 million?
Representative Thompson.
I wanted 10 million. No, with all due respect, I wanted to ask for 10 million. I think this is a long overdue conversation, and you can't put a price tag, but I want it to be, I don't want to go outrageous, but I want to make sure that the work is done right. And so when we come to the $2 million conclusion, it was a meeting between all of us and said, well, we can get this done. You know, a lot of times we try to do the work, and I've always seen several studies by people about us, by people who don't look like us. And they don't get an accurate synopsis of what we really need in our community. So this was driven by people who actually want to do this work and have this conversation. I'm always willing to, for me as a union, I was a machinist, but I was also part of the bargaining unit. And I've always heard that there's always a different price. So honestly, we just need what everybody else need in the community, and that's help, like getting this piece of legislation off the ground and moving. And hopefully we could actually all come together. And thank you so much.
Thank you, Representative Thompson. And I will say too that, it would be my intention with laying this over that we would work with the Department of Human Rights, since this would be through the department, to make sure that we're going about this in the best way to get to the results that we're all looking for. Follow-up, Representative Scott.
No further follow-up, Madam Chair.
All right, thank you. Representative Frazier.
Thank you, Madam Chair. Thank you, Representative Thompson, for authoring the bill, and thank you, community members, and all those that testified and shared your knowledge, your lived experience, and your expertise. It was needed today, and this is a conversation. And I agree, Representative Thompson, it is long overdue. In fact, not only in the state of Minnesota, but in this country. We have an original sin of chattel slavery. We know that. We can directly draw a lot of disparities and inequities that we have in this country back to that original sin. The problem that we've had is having a real deep, serious, and thoughtful, sincere conversation about that, and then taking action to correct those wrongs. We see it every day. I see it every day in these committees when we try to bring forth policies to correct past historical wrongs, and there's a lot of pushback against that. So this conversation is long overdue. I'm looking forward to working with the chair and figuring out how we can get it moving forward and actually make something happen. I think it's a way to help not only the state of Minnesota heal from those past wrongs, but maybe we can be a model to the country. Thank you for bringing the bill.
Thank you, Representative Frazier. I'm going to go to Representative Johnson, and then we're going to lay this over. Representative Johnson.
Chair Becker-Finn, Representative Thompson. I've been doing while we're sitting here doing some searching, and like Representative Scott mentioned, other than the Facebook page of Minnesota Mitigation Act is just a Facebook page. I was looking up your, what was the term, secrets for truth. All I can find is music videos. If this is going to move forward, we need information on what this group is, what it does, information about it, who is the board of directors, is it a 501c3? We need to be able to look into it to make sure the funds are going to the proper person. And if they're not, that we have somebody to go after if those funds are misused. So I guess we need a lot more information on this organization. If it actually, I'm not saying it's not there, but we need information that we can actually look up and find out information on. And with that, I'll let the chair lay it over.
Great. Thank you, Representative Johnson. And I'll just say, I'm going to start with a place of, I really hope that folks took more away from the testimony today than Googling some organizations. I think what really came through to me in the testimony today was how important these efforts are. And again, we're laying this over. Nobody's going to be voting on it today. We're laying this over so we can get this right. And at that time we can talk about that. But I think to assume that there's going to be any mismanagement of anything, we're just laying this bill over today, is a little premature. So again, just really want to thank the testifiers. Representative Thompson, any closing comments before we lay this over?
Real quick, for 403 years, American descendants of chattel slavery have endured subhuman treatment in America. Often we talk about slavery here, like we think of Southern plantations, and few acknowledge like the connection to slavery right here in Minnesota. Like, for instance, 1840, you're talking about Dred and Harriet Scott, who were like even through slavery. This is a conversation. You're right, that was well overdue. I want to share something. This is my honest thought. Right now, we're still in chains. Some may have platinum chains, some may have gold chains, some may have silver chains. And they brag about, look, my chain's silver, look, my chain's gold, but we're all still in chains. And I'm not just talking about Black people. I'm not just talking about African Americans. Here's what I also will share. Currently, when we think about it, post George Floyd came here for drug rehab and a job training. He wanted to be a truck driver. Instead, we fed him fentanyl, and ultimately we killed him. And I'm talking about the entire state of Minnesota. And so I want to I'll share that we're not going to see the fruit of our labor here. Everybody here on this call, we will not see the fruit of our labor. Right now, we're actually living and benefiting off the fruit of the man that's behind me, some of the hard work that this man put in. Our kids, I have a 13-year-old son, and I'm hoping that my son will benefit off of some of the decisions that we make. Because we can no longer go back to, we're still asking for things that Martin Luther King, Malcolm X, and some other civil rights, we're still asking for these things in 2022. And so I know that this conversation is well overdue. I want to say thank you to everybody on this committee for allowing me to have this conversation. I mean, a lot of times we attack people, but we don't attack the problem. And I'm ready to attack the problem. And I want to say thank you again for having me. Please consider this bill as important legislation for you.
Thank you, Representative Thompson. Again, thank you to all of our testifiers. It was really important to hear from all of you today, and really appreciated folks hanging in there for this late committee hearing. With that, House File 3850 is laid over for possible inclusion in an omnibus bill. That brings us to the last bill on our agenda today, members, House File 4200, Representative Frazier. Representative Frazier, do you want to move your bill to refer back to the Public Safety Committee?
Yes, Madam Chair, that is my motion.
All right. And I do want to address, we did get an amendment. It came in late, so we're not going to be moving the amendment. I know there was some confusion about the way that it was titled. But I do like to stick to my deadlines when I have rules for people, even Representative Frazier. So we won't be moving that amendment, but we did want to make sure it was posted because the intention is that that amendment will go on in public safety. And we just want to make sure that folks have the information in front of them that is the intent for the final, or at least the bill as it's going to move forward in the House. And so we don't need to move the amendment, but I just want to explain that, and that's what's going on. And the amendment is available to all of our members to take a look at. And with that, Representative Frazier, please tell us about your bill, the provisions that we need to go over here in the Judiciary Committee.
Thank you, Madam Chair. And the only provisions that are appropriate for the jurisdiction of this committee are the body camera provisions and also the civilian review board provisions that are listed in the bill. And I just speaking to that amendment, and Chair, I apologize for not getting in on time, meeting that deadline, but I appreciate the ability to at least discuss it so it's before the committee, so then when I bring it back, we can move quickly to not have this take up much time on your agenda. The amendment is for body camera footage, and it allows for body camera footage to be viewable after no longer than after 5 days after there is an engagement with officers with the use of force or the use of deadly force. And then after that, 14 days available to public. Now, with that provision, it does allow for the chief law enforcement officer or the agency to provide information to not release that footage if they believe it will have an impact on the investigation that is ongoing. And then it also allows a mechanism for the family or party seeking to have access to that information to have a district court, ability to go through district court to seek them to allow the information, the data to be released. I do have Superintendent Drew Evans here. This language that I will adopt into the bill, and I can just be specific, this language will be adopted into Article 3, Clause B, and it will replace paragraphs 4 and 5, and then Article 2, Section 2, Subdivision 4, paragraphs 2 and 3, as well. This language will be adopted and replace the current language that is there, just for members to have that information for review if they'd like to. But Superintendent is here, Drew Evans is here to discuss. This is language that was drafted and provided from the agency, and I'd like him to speak to it if he could, and then I will discuss the other provisions in the bill, Madam Chair, if that's okay.
Yep. Mr. Evans, if you want to introduce yourself and go ahead with your testimony.
Thank you, Madam Chair. My name is Drew Evans. I'm the superintendent at the Minnesota Bureau of Criminal Apprehension, and thank you for having me in front of your committee tonight to speak to this. As Representative Frazier referenced, that there's been a lot of information shared about this, and we've heard certainly from community members, law enforcement, and law enforcement agencies across the state of Minnesota. And I know this has been an issue in front of your committee. At the BCA, as many of you are familiar, we investigate many of the officer-involved shooting incidents and use of force incidents across the state of Minnesota through our independent force investigations unit that is housed at the BCA. One of the topics that comes up on a regular basis is the release of body camera footage after the conclusion of one of these events in our communities. The language that was drafted here is drafted after hearings of those concerns, and what it would do is bring consistency so that we have community expectations of exactly what will happen within a specified time frame after one of these incidents occurred. The timeframes that were introduced in this bill or proposed as that mirror the language that has been adopted into the state body camera policies by the state law enforcement agencies. That is the current process that is in place in our policies, both for the BCA, State Patrol, Alcohol and Gambling Enforcement Division, and the DNR Enforcement Division. The timeframes that are suggested here as well, I can also say that, generally speaking, would comply with our investigative process and the processes I've had in place in our investigations in working in conjunction with those law enforcement agencies the majority of the time, we're able to meet those timeframes. And then the provisions in the bill are there that if we are trying to track down a key witness or there's something that would truly impact the investigation, there's a mechanism in place that would allow to pause that, either delay or prevent that until a case is dismissed. But there's a mechanism, as Representative Frazier noted, to challenge that assertion if that were to be exercised. But I think the provisions here in the bill would provide multiple mechanisms to ensure transparency, accountability in our process along the way. And so that is the language that is shared here today. And certainly happy to answer any questions about those provisions or any of the work related to that and how that has worked across Minnesota. But I certainly would say, being on the investigative side, having a set a timeline into releasing this video so that there is a very clear expectation of when that will be out certainly will aid in that transparency and concern that we've seen in communities across Minnesota.
All right, thank you for your testimony. Back to you, Representative Frazier.
Thank you, Superintendent Evans, and thank you for being here and thank you for sharing it. I agree with what the superintendent just said about increasing that transparency, and also it will help build trust. One of the reasons that I'm really appreciative of this language is because it's in conjunction in conversations with law enforcement and community, and I think it addresses the concerns in a thoughtful way to address the needs of law enforcement to do their investigation without it being impacted or impeded, and also with community with being able to have a clear timeline of when they'll be able to have access to that footage. And I think having a uniform policy statewide will be helpful to building trust and transparency across the state in all of our law enforcement agencies. So I hope we can finally move this language forward. It's been a long time having these conversations. So thank you, Superintendent Evans. So I'm moving on. The other provisions in the body camera language are pretty straightforward. This is language that we provided last year, so it's not new to you. We're bringing the language back with hopes that we can have more conversations and the ability to move forward this year. Essentially, this language is tied to our body camera grants. If individual agencies do take part in receiving this grant funding for body cameras, they will be required to adopt certain policies that will require them to, for one, to release the data according to this amended language that I'm going to adopt, and also to make sure that they keep their cameras on, they keep their cameras on when they're engaging in police activity, as well as not to have any interference or redacting or changing any of the data on those body cameras as well. And then the other piece is the Civilian Review Board that I'll go through quickly. Again, it's the same language that we brought last year that was heard in this committee. Nothing changed. This is permissive language. It allows for city councils to develop. We already know it. City councils can already develop civilian review boards, but they don't have the ability to give them certain powers. This bill will allow them to give them subpoena powers and the authority to do investigations and to provide recommendations. Again, it's permissive. So again, what would happen is that civilian review board will really reflect what that community wants out of their civilian review board. So it's really the local control that we frequently talk about here. It will be there for the municipalities and the civilian review boards that they put together. I actually had a conversation with one of our tribal leaders. And then what he said to me was that he was considering developing the civilian review board for the purposes of having a connection between law enforcement and the community to have those conversations and talk about what works best for their community. So I was encouraged by that, and I hope he carries through with that idea. But this, again, when the Civilian Review Board does take any action based on the authority that their local municipality or city councils give them, that action can be, it is up to the chief law enforcement officer as whether or not they will enforce those recommendations or any actions provided in those recommendations to that chief law enforcement officer. Still, the control is there from chief law enforcement officer that is close to those officers and close to the situation to make those decisions. And any of the information, any of the actions that are being taken will not be outside of the collective bargaining agreements or the workers' protection laws that we have here in the state of Minnesota. So we'll be beholden to those contracts and the grievance process, and that data will still be considered to be personnel data under Chapter 13. And that those are the provisions that are here before the committee today for conversation or discussion. I'll stand for questions, or I'll sit virtually in my kitchen for questions.
Yeah, we're so close to dinner time. Thank you, Representative Frazier. On to member discussion, Representative Johnson.
Chair Becker-Finn, Representative Frazier, we're back at it again. I understand your passion for this. There's some issues down in Minneapolis and St. Paul, especially with the huge increase in crime and violent crime. Unfortunately, it's spreading out to other areas around the metro area.
Representative Johnson, I just want to remind you, it's not the whole bill in front of us, so we're not back at it again. We're just going to talk about the body camera data policy and whether that should be the release schedule. If we can stick to that, please, Representative Johnson.
I understand. And that's what I'm talking about. We've had this bill before us numerous times over the years. I do have a question for Commissioner Evans, Deputy. I'm just wondering, one thing that has to be done, and it's in the current law as well, and current statutes, is, and it's staying in there by reading the amendment, is the requirement to redact information. Can you, I know the ruling was about 1 hour for every minute of redaction. Is that, I just wondering if that still holds true. Then I'll have a few other questions after that.
Superintendent Evans.
Madam Chair, Representative Johnson, I will say there's been advances in the ability to redact, in particular, depending on the body camera equipment that's being utilized. Axon, for example, is a widely adopted body camera, and they do have tools that they've developed that have made it much easier. I don't have an exact number for you, but I would say that timeline has greatly shrunk in terms of the redaction that needs to occur in those. In addition, the statute as read is fairly narrow in terms of what is released under the statute. It's the actual use of force incident itself. So we have made progress in being able to do that more quickly, but it depends on the case.
Representative Johnson.
Chair Becker-Finn, Superintendent Evans, and I understand it does take time in the investigation. They a lot of times do take a lot of time. The concern I have is with the 5 days. I think it should be whenever practical, or as soon as practical. I remember an incident I was on. I was fortunate. I did not pull the trigger, but I was shot at by the perpetrator, and a different officer returned fire. I know there was well over 20 officers there, 20 different squad cars. Figuring that out, we were there for 9 hours. And the way the bill reads is any and all video. If it's just 20 officers and 20 squad cars for 9 hours, that's 360 hours of video that needs to be redacted. I don't think that, even with the advances now, I don't think that could be done in the 5 days with the advancements we have. So depending on the incident, everything is different. And I know there's been times that BCA has said not to release video camera as the investigating agency or video footage, but it was released anyway. And I believe that sometimes can hurt an investigation. Then we also have the issue of malfunctions. I know my squad video malfunctioned more than once. Even though I turned it on, it didn't record anything. Is there, Representative Frazier, is there anything in this bill dealing with the equipment malfunctions where the officer could be get into trouble or be reprimanded or disciplined because of the malfunctioning of the equipment?
Representative Frazier.
There's nothing in the bill that would suggest that an officer should be punished because the equipment is faulty. So no, Representative Johnson.
Representative Johnson.
The Representative Chair Becker-Finn, Representative Frazier. I think that's something that needs to be looked at because the bill says the video has to be recorded. Your amendment says the equipment has to be turned on.
Yeah.
But if it's malfunctioning, it may have been turned on but doesn't work. And that could lead to a disciplinary procedure against that officer, even though it's a malfunction. So we have to be careful how we write things and how we put it into statute to make, and that's one thing I like about this judiciary and especially civil law. And I believe every member of this state of representatives should spend time on civil law because it really makes you look at consequences. I hope you can hear me. My earbud just died.
We can hear you.
So with that, I will turn it back over to Chair Becker-Finn.
All right, thank you for your comments. Representative Scott.
Thanks, Madam Chair. Representative Frazier, does this amendment address the issue of the requirement to retain the deadly force tapes forever? Or is that in the body of the underlying bill?
That's in the body.
Representative Frazier. We're tired. It's all right.
So I know I get late. Thank you, Madam Chair. Representative Scott, that's in the body of the bill.
Okay.
Representative Scott.
Thank you, Madam Chair. And so what was the onus for retaining that data forever?
Representative Frazier.
Thank you, Madam Chair. We just believe that is data that could be important down the line, and we just wanted to make sure that it doesn't get destroyed.
Representative Scott.
Okay. So I guess my only other issue with this bill, I guess, is the subpoena power piece. And subpoena power is a pretty powerful thing. Yeah. And I just don't have a level of comfort with a citizen board having that level of authority over, over an officer or whoever. I think it's better left to the courts. And I know the legislature has subpoena power. Maybe I saw it used once, but it's something that it carries a lot of weight. And so I have some concerns with that. That's my only questions, Madam Chair. Thank you.
All right, thank you. Not seeing any other hands up. Closing comments, Representative Frazier.
Yeah, just in closing, and I'll respond to Representative Scott's unreadiness around the subpoena power. Again, this would be up to the local councils, and I know when I talk to some of my local officers, they feel comfortable that their local city council will understand what's happening between the community and law enforcement. They will do what's best for the community and law enforcement in those situations. So I would imagine in many of those situations, there may not be a need to provide to civilian review authorities with subpoena power to carry out any of the functions that they may want to carry out. In most cases, I believe those civilian review boards will be used to build very good relationships and to be a conduit and be advisory boards between the community and law enforcement. That's the way I believe most of this will be. But we wanted to give the ability of city councils, if they decided that that's what they wanted to do with their civilian review boards, they could do that. But just in closing, members, thank you for reviewing this. I'll get my amendments in on time and we'll be ready so we can present it and we can move the bill forward back into public safety so we can have a robust conversation. Representative Scott, Representative Johnson.
Yeah, thank you, Representative Frazier. So what we will do just to make sure everything's on the up and up is that we will move the bill and vote on the amendment on Thursday, but we've already fully discussed it today. So but I want to make sure we're crossing all the T's and dotting all the I's and doing this in the most fair way possible. So that will be the plan on Thursday. We'll get that moved and properly amended and moved on to back to public safety. And hi, Langston, for visiting us. We're about to wrap up for the night. So with that, I'm going to lay over House File 4200, and we'll pick it back up on Thursday. Thank you, members, for a busy day. We got a lot of work done. I really appreciate all of you. With that, we are adjourned.